You can be prosecuted and go to jail for possession of marijuana in Florida because marijuana remains illegal. Recently, marijuana was on the ballot in Florida as a proposed amendment to the Florida Constitution, known as Amendment 3. This proposed amendment would have legalized the recreational use of marijuana for people aged 21 and older. 55.9% of voters in Florida voted to amend the Florida Constitution to legalize recreational use of marijuana for people aged 21 and older. However, in Florida, an amendment requires that at least 60% of voters vote yes for an amendment to pass, therefore proposed Amendment 3 failed. This video provides an overview of Florida's laws and penalties related to marijuana, focusing on possession, delivery, trafficking, and medical use under Florida Constitution Article 10, Section 29, which governs medical marijuana production, possession, and use. Possession and delivery of marijuana. Delivering 20 grams or less of cannabis without consideration is classified as a misdemeanor of the first degree. In Florida, the penalties for a first-degree misdemeanor can include up to 1 year in jail, up to $1,000 in fines, up to 1 year of probation, community service, educational classes, individual or group counseling, and random drug testing. It is worth pointing out that because possession of marijuana remains illegal, if you are on probation or test positive for marijuana, it can be considered a violation of your probation. Trafficking marijuana. Florida law mandates a minimum term of imprisonment and fines for possessing large quantities of cannabis. Possessing large quantities of cannabis is considered trafficking. The minimum terms of imprisonment and fines for trafficking marijuana in Florida depend on the quantity of cannabis involved. For quantities in excess of 25 pounds but less than 2,000 pounds, or 300 or more cannabis plants, but not more than 2,000 cannabis plants, the mandatory minimum term of imprisonment is 3 years, and the fine is $25,000. For quantities of 2,000 pounds or more but less than 10,000 pounds, or 2,000 or more cannabis plants, but not more than 10,000 cannabis plants, the mandatory minimum term of imprisonment is 7 years, and the fine is $50,000. For quantities of 10,000 pounds or more, or 10,000 or more cannabis plants, the mandatory minimum term of imprisonment is 15 years, and the fine is $200,000. These penalties are strictly enforced and are designed to address the severity of the offense based on the amount of cannabis involved. Because trafficking marijuana includes minimum mandatory terms of imprisonment and fines, judges do not have discretion to give sentences less than the mandatory minimum. Medical use of marijuana. The medical use of marijuana is regulated, including restrictions on its possession, use, and administration in Florida. Florida law prohibits the use of marijuana in certain public places and outlines the requirements for physician certification and reporting related to medical marijuana use. In Florida, patients, caregivers, and physicians are protected from criminal or civil liability when they comply with Florida Constitution, Article 10, Section 29 regarding medical marijuana. An electronic medical marijuana use registry maintained by the Department of Health is used in Florida for tracking and regulating medical marijuana use. The registry has accessibility to law enforcement and physicians to ensure that only authorized individuals can access medical marijuana because the state of Florida wants to prevent misuse of marijuana and to ensure compliance with state laws. The Office of Medical Marijuana Use was established under the Department of Health in Florida to centralize the administration and enforcement of medical marijuana regulations. The role of this office is to investigate new drugs and ensure that medical marijuana use is regulated effectively. Florida regulations require informed consent forms and thorough documentation to be maintained by physicians to ensure medical marijuana is prescribed and used responsibly. The government of Florida has put these standards in place to ensure that marijuana is only prescribed when medically necessary and that its use is closely monitored. Had Amendment 3 passed, these statewide regulations on the recreational use of marijuana would no longer be necessary, and possession of small amounts of marijuana would no longer have been prosecuted. Florida's legal framework for marijuana includes stringent regulations and penalties for possession, delivery, trafficking, and medical use. Florida law imposes severe penalties for violations of the law. Public perception of marijuana is that it is not a dangerous drug. However, Florida law still imposes severe penalties for possession and trafficking. Tanner Demmery of Demmery Law is a former prosecutor and public defender who has nearly 20 years of experience handling drug crimes through jury trial. Tanner has the unique experience of having both prosecuted and defended drug crimes through trial in Florida. If you, or someone you know, has been charged with a drug crime, Demmery Law can help you. Contact Tanner Demmery at 954-224-0577 or email Tanner@demmerylaw.com.